Hi, everybody. Tim Andersen here. We appreciate the fact you're with us today. Thank you very much. Today, our guest is wonderful, a man we've had before, Mr. Craig Capilla, an attorney extraordinaire, an attorney who understands appraising, an attorney who understands how we think. Craig, how are you this morning?
I'm wonderful, Tim. How are you?
Great. Thank you. I appreciate your asking. I understand that today was the first day of school and there were some kiddies to get out the door. Is that right?
That is correct. They keep getting older faster. So I now have a sixth grader and a second grader. So we got them hustled out the door this morning and into their new classrooms. And by this afternoon, they will have forgotten about us again.
They tend to do that, especially when they turn 21. Anyway, um, let's talk about some items that have hit appraisal world relatively hard. Now, we might or might not get into Sitzer Burnett. You and I have covered that. But let's get into ROVs. And we may run into Sitzer Burnett, but let's talk about ROVs primarily. Okay, now, basically, we've got a situation where in the past, USPAP said, hey, appraisers, you get to choose the client, you get to choose the intended user. Well, all of a sudden, this ROV process comes along. And now, all of a sudden, the borrower to whom we have no fiduciary, to whom we have no contractual relationship, with whom we have no relationship whatsoever, is now able to say, "Hey, AMC, this appraiser just did me dirty. I want to file a reconsideration of value." And the AMC, the lender, they've got some input on that, and we're going to talk about that in a minute. But basically, the borrower has now become an intended user, even though we don't mention them as intended users. So my question is basically, where does this put the use path from a standard of enforcement, from a standard of being the rules, etc., when all of a sudden they're not the rules anymore, but yet we have to play by a different set of rules?
So there's an interesting mix of factors that goes into this one. And I'm glad you kind of led right into the use PEP question because my understanding from what I've read from the GSEs about their processes that they're I'm going to say refining. If people recall, ROVs have actually been around for a very long time. This is not, in fact, something new under the sun here. This is an attempt to reconfigure the process so that it's more widely understood and, for better or for worse, that it's more widely utilized. So one of the things that comes into play here is the process itself. What's changing? What's staying the same? And what does that mean for the appraiser, respective to their other obligations, license law, use PAP, and the like? There's a good bit of question going on around there. And I will tell you again, I let me just get out in front of this right off the bat. I am actually in favor of the ROV process, and I am in favor of the updates that we're seeing. I have significant concerns about two factors, and that'll come right back into the answer to your initial question. One, I'm very concerned about the messaging around it. I don't know that everybody understands. I don't know that it's being effectively communicated what the basic idea here is, why we're even bringing ROVs up again. And I don't know that everyone truly understands the process as it was and as it will be, so that we can make sure that we're all still adhering to license law requirements, USPAP, other regulatory standards as they may apply. So to the USPAP question, appraisers are still, as always, we've commented this probably every time you and I have spoken. There's one of us usually utters the line something to do with the fact that you just can't switch USPAP on and off. It's on. It walks among us. It's always functioning here. Nothing in the ROV space either A, relieves an appraiser from any obligations or responsibilities under USPAP. nor does it actually run afoul of any of those concerns if all of the participants in the process actually understand how this is supposed to work. While the borrower is not, for purposes of the appraisal report, an intended user, we know that that horse got out of the barn years and years ago when it became a requirement that the borrower must be presented with a copy of the appraisal report. Now, what we're seeing here, and we'll get into the background of this a little bit, what we're seeing here with this renewed focus on the ROV process and why we're shouting it from the rooftops, it's not actually all that different than it was before, but we're really trying to get out and push publicly that it exists. There is, in the context of the GSEs and really government agencies all over the board, so anything FHFA on down, there is a tremendous concern about the bias and discrimination claims that we have seen, and you and I have discussed rather extensively over the last several years. Making sure that the borrowers that are out there understand that an ROV process exists and that they should be attempting to use it if they have reasonable or legitimate concerns is an attempt to get out ahead of and address some of those bias and discrimination claims. And that's where I come on board with saying I'm very supportive of the ROV process. Of all of the bias and discrimination cases that I'm working on at the HUD level, at the state level, wherever they may be, I'm a firm believer that a properly utilized ROV might have, not in every case, but might have for many of them alleviated the concerns before the regulatory complaint ever got filed at HUD or at a state human rights commission or at whatever level it's at. If there are legitimate concerns about the processes of the appraiser or the veracity of the data used, there should be a mechanism to address that without throwing it at a federal alphabet agency that is not equipped to handle the problem and staffed with a series of subject matter experts that now have to learn about appraisal practice on the fly. So that's the backdrop with this ROV push is there should be a tool for people to raise legitimate concerns. You'll notice I keep using that L word in there. We're going to come to that. There should be a process for consumers to raise legitimate concerns about valuation. Now, the process for that is it has to be borrower initiated. So one of the questions that I get about this all the time is, well, what happens when the real estate agent, when the real estate broker decides that they're going to advance one of these things with the sales they wish the appraiser would have used? They're not taking an ROV from a broker, from an agent. In fact, this process, though it doesn't say it clearly, and I wish it had, because that's, again, this is part of the messaging concern I have. I think a lot of this was drafted in a bit of an echo chamber. This is intended really for the refinance process. When the borrower is in their home and now they're looking to refinance and they have an appraisal that comes back that does not meet their expectation, whatever their expectation was, right or wrong, and they want to express concerns. The process as considered here is intended to give those borrowers an outlet rather than running to HUD or CFPB and immediately asserting its discrimination. If it's, hey, you know what? There's other sales that I know about over there. Those should have been used. The ROV process can come back with a thoughtful response. See, we're aware of those sales, but those sales were not appropriate in the circumstance because A, B, C, D. That should be able to turn the temperature down and take some of the animus out of things that evolve into a bias or discrimination claim when you've got a concern here where either the disgruntled borrower is just not getting any feedback whatsoever, or they go direct to the appraiser and the appraiser correctly, though brusquely, says, I can't talk to you, click, and hangs up. And that's just throwing gasoline on the fire. So understand the broker, the agent, shouldn't be in the ball game at all here. Now, are they going to be involved at some level? Are they going to identify some additional closed sales that they may want to push through their borrower on a transaction level? Yeah, I'm sure that will happen here, but understand that the ROV process has to be borrower invoked. So it's intended to be a refi scenario. And then it still pushes this through a process by which the lender and the AMC still have to act as filters before it gets to the appraiser, meaning the appraiser's requirements to communicate only with their client and intended users as identified in this is wholly maintained. And so we don't get outside of our lane in USPAP. That's the thought. And I realized that was a bit of a meandering answer, but I wanted to set the table for a bit of what's going on here and at least what the intent is. I'm not sure that we've fully got it in place where it's meeting its intent perfectly, but that's the thought process behind why this is coming up now.
Okay, so what you're saying is it's got to start someplace, and it's going to start now, and it's going to start here. And it's possible that it can be refined over time. Okay, all right. Now, you mentioned that the ROV process now must be borrower initiated. Okay, that is a narrowing of the process that possibly didn't exist before. Okay, now let's talk about that narrowing process. The way the ROVs are set up across the various GSEs, there has to be somebody with either the lender or the AMC who is going to act as, for lack of a better term, a gatekeeper, who has got to receive the request, has got to look at it and say, well, okay, there's enough here. And then has got to provide the paperwork. And in other words, there's going to be somebody who is administering this thing between the borrower, the lender, and the appraiser. Now, there are only three reasons that the borrower can invoke an ROV. That the borrower feels that the value opinion is lacks support. Now, how a borrower is going to know that, I'm not entirely sure, but that's a question for another day. The second one is the appraisal itself is deficient because the appraiser engaged in one of the 16 unacceptable appraisal practices that are available on the GSE's websites if you want to go check those out. And then the third one is the borrower feels that he, she, or they have been the appraisal was the result of discrimination or bias. Now, here's my question, and I don't mean to be obscene or earthy, but I do mean to be obscene or earthy. When this comes back, when the borrower says, "Okay, no, I'm going to file an ROV. This just isn't right," and it has to go through this middle person, this administrative person at the lender or the ROV. Really, is this person gonna have the balls to say, no, there's really nothing here. You got no reason to file a complaint. Uh, go have an adult beverage and relax. I'm, and I admit I'm cynical, and I'm just thinking that one of these things is going to come in, and that poor person, that poor administrative person, is going to say, well, I can either keep my job and file the ROV, or I can recognize that there's absolutely nothing here and this shouldn't be filed. So, what are your thoughts on that issue?
That's actually a great question. And I have a number of thoughts on that issue. So understand that every layer of the process here is going to have somebody that is ultimately responsible for receiving, processing ROVs. I think that this ultimately winds up with the appraiser, the appraisal management company, where there is one, and the lender, somebody in underwriting, really all on the same side of the line, when there is a concern about bias or discrimination. And truth be told, there's the three reasons that you can bring up an ROV. I'm not sure any of the three can really be separated because it's questions about the support of a value and questions about whether or not the appraisal is deficient that lead into whether or not there was bias or discrimination. You cannot have one without the other. So I understand they've enumerated these 3 points. I think you can have questions about support without it being a bias question. I think you can have questions about deficiencies without it being a bias question. You cannot have a question about bias without it being debating the support and deficiencies. So those are inseparable in my book, meaning that this is all going to go back to who is really reviewing. And I don't mean just QC checks. I mean an actual review. Who is really reviewing these reports to determine whether or not these reports are credible? And when that event arises, everybody down the chain, the lender, the AMC where one exists, and the appraiser are all on the same side of the line in that question because they're all sitting in the chairs next to each other when the discrimination complaint goes forward. And so while I do think the initial inclination is going to be from the lender end or from the AMC end, oh, hold on, let me fire this at the appraiser and start getting a response. I think it's going to have to be a collaborative or a cooperative effort. It's going to have to be, hey, appraiser, you need to be aware that this ROV has come in. This is what's being asserted in this ROV. This is where the concerns are. What is your response for that? Get the response back. I'm not sure that's answering the question for me all the way. I'm not sending that to the borrower yet. Can you give me a little more information about this? In the meantime, I think at those additional middle ground layers, they're going to have to be involved as well as, this is how we took it in. This is how we reviewed it to begin with to consider whether or not it was credible, and we could pass it through to the lender client. At the lender end, this is what we received. This is the checks that we ran it through on our end to determine whether or not we could rely on this in furtherance of a mortgage decision, because everybody at that point is attached to each other for purposes of a bias or discrimination claim. And so it's going to create more work for folks, but it's going to create, ideally, it's going to create a reduced liability scenario, because otherwise everybody's going to end up having to hire their team of lawyers to address the lawsuit or the investigation from a federal alphabet agency regarding bias or discrimination. And that, again, I know, and I've heard countless times, appraisers do not appreciate the additional work that keeps getting heaped on them by, frequently the GSEs, frequently by legislation run amok. I mean, there's a good bit of tail wagging the dog in all of these things. When we always instruct appraisers, you drive the bus. You are the expert in that assignment and that subject property at that date and time. You dictate what's the scope of work, what's the necessary process for completing an credible appraisal here. But after you've done that, we need you to do these 38 other things and add that in there for us too. Okay. I understand what the dichotomy is there. And this, for a lot of appraisers, is great. This is just one more thing where they're going to come back to me. Now it's not revision requests anymore. Now it's ROVs, and they're going to come back to me with, here's 38 more sales, and we need you to go ahead and we need you to map out and analyze all these sales and include this. And this is one more thing that I'm not getting paid for. And this isn't that. It has the appearance of that based on all of the things that you've seen over the last decade and a half of adding on additional requirements and requests from lender clients and GSEs and the like. The ROV process, or the renewal, I'll say, of the ROV process and the awareness thereof, is a completely different intent. It's actually intended to help restrict or refine the liability pool that's out there. It's not intended to create more obligations for anyone else. And everyone in the process, from the appraiser to the appraisal management company to the lender, and really at the end of the day, this is only a matter of time until this happens, the GSEs themselves, everybody out there is on the hook for being responsive to legitimate consumer concerns and what their respective actions have been to address or combat discrimination and bias. And that's really what we're looking at here. So I expect the people that are involved, I'm thinking of a few AMCs right now, I'm thinking of a few lenders right now, and I'm betting if I had to put my list out of who's going to be the individual internally to each of those organizations that's tasked with filtering and detailing these things, I bet I'd have a pretty good hit rate of guessing who the people are in the organizations that are going to get tasked with this job and it's going to land on their desk. And yeah, they're going to take this very seriously, and they're not just going to push it onto the appraiser to create more work, because they understand the liability environment too. And if they shortchange this, if they don't meet what their requirements are as an AMC or a lender, they're going to be sitting right next to the appraiser if all of this goes sideways, which, tangent here, but it's another factor in all of this that I think is significant. We just need to make sure everyone understands it and that it has to be addressed sufficiently. I can't tell you how many of the cases that I've had on bias and discrimination where one of the questions that gets asked, at least at the HUD level, sometimes at the state level, is give us a list of all of the reconsiderations of value that you've had over the last X number of years. And they give that request to the appraiser. And oftentimes the appraiser will say, oh, I haven't had any ROVs, or give me all of the communications related to the ROV on this assignment that's the subject to a bias claim. And there aren't any. That hasn't always meant that the borrower didn't initiate an ROV. We've had a bad track record out there of the other participants in the process, lender, AMC, looking at it going, there's no merit to this. There's no there. I'm not even going to bother the appraiser with this one. We'll just shoot them back a response, tell them their ROV didn't move anything and it was insufficient, and we'll move on. And the appraiser gets completely blasted out of left field with a bias complaint, sometimes even a state board complaint. They get called in to sit in front of their state regulator. Will explain what happened in this process. They gave you these additional sales. And appraiser's going, oh, no, nobody ever gave me anything. One of the other items that this update is intended to fix is, regardless of whether or not there's merit and they push additional data back for consideration to the appraiser should be notified that an ROV was initiated. That's also part of the gatekeeping process, is if it doesn't meet the requirements of being a proper ROV, that has to be clipped at the lender level immediately. And it shouldn't be registered within as, oh, there was an ROV that went unanswered, because enough is enough. Appraisers need to stop getting hamstrung by something that they've never been made aware of. And I can tell you, it's an incredibly awkward process for an appraiser to try to have to answer that question at a later date when they were never made aware of it to begin with. So this is also intended to address that concern. And whether it has merit or not, whether it really gets off the ground, if it comes in as a proper ROV, the appraiser is going to be notified about it. Sometimes even as simple as, hey, just so you know, we've received an ROV on this, but based on what we're seeing, we have no further questions for you, the appraiser. It seems that everything that you've done is in order and their request really doesn't have any merit. Fine. But that way you'll have a note, you'll have something that you can put in your work file that says, this goes to this appraisal assignment as well, and now I've got it. And if the question ever comes up later, hey, what happened with this? Why didn't you consider X, Y, and Z? Oh, look, it says right here, nobody even presented that to me. It was considered above me, and it never got to my level. So there was nothing for me to consider. Because part of this, again, is also building out a more robust process so that it answers some of the questions out there that regulators have before those questions get asked.
All right, thank you, Craig. Relative to a more robust process, in all fairness to the borrower, and then the lender and the AMC, the lender, the AMC, et cetera, the borrower. can submit only 5 more sales for consideration to the appraiser. And when you mentioned 38, you were using hyperbole to make a point.
That's actually a number that I've had said to me. And Tim, you're 1,000% correct. If people go through and actually read what the tightening requirements are about an ROV, 5, pick your best 5. That's all you get. If you've got 2 or 3, those are fine. If you've got 38, pick your best 5. But what I'm hearing from folks who are very lathered up about this, because it's going to create more work and make us do more things, is, well, they're going to send us this many and this many. And I'm not kidding. Actually, I didn't even make up the 38. I've had that said to me. And I think if I recall correctly, the follow up was, and then when we don't move our number off of that one, they're going to come up with some more. No, they're not. It's 5. It's one shot deal, and that's it. And that is important for people to know. It's, again, I think it's published out there. You knew it. You found it. I've seen it. I'm not sure everyone's hearing that. I think it's part of the communication problem again.
It's I'm not trying to say it's buried in the fine print, because it's not. But yeah, the appraiser is going to have to do that research. But yeah, you get one shot, 5, and then you're done. If those 5 don't move the needle ain't moving. And I sent you this morning something I put together on the individual ROV requirements for the individual GSEs. And again, if somebody wants a copy of that, it's free. I'll be happy to email it to you. Just contact me, and I'll be happy to send that document to you. Now, okay, Craig, the cynic in me is coming out again, and we've known each other a long time, and we work together, and I'm cynical. Okay, now the contract's $450,000, and the appraisal comes in at 412. All right, and the borrower says, "Well, okay, maybe we can just renegotiate the deal." And another party, maybe it's the lender, maybe it's the broker, maybe it's somebody's brother-in-law, says, "You know what? Really, what you got to do is you ought to file an ROV, and let's see if we can scare the appraiser, and get this thing up and make sure you can really borrow the amount of money you need." So what I'm saying is, given that the ROV process has indeed been narrowed, and it has indeed been narrowed in the appraiser's favor, quite frankly, do you think that this outside pressure is going to be something that appraisers are going to need to worry about? Or do you think that the middleman that we've been talking about is going to be able to take a look at the complaint and say, nah, this is just somebody's brother-in-law getting bent out of shape, and no, there's nothing here. We're just gonna, we're gonna tell the appraiser one's been filed, but we're not going to follow up because there's nothing here? Or is that middle person going to say, well, it came in, I guess I better file it, better notify the appraiser and start the paperwork?
I think there's a couple of layers to that. And I think we're going to see the spectrum. I don't think there's a one size fits all answer to that. But now, again, understanding that most of the framework that we're seeing here is done really intending to address refinance concerns, which means one of the areas that I think we're going to have to go back to the drawing board a bit with this is to bring more clarity, to be more refined about a transaction scenario where this is now going to be a buyer initiated borrower ROV, right? Which means who gets to initiate this again? The seller doesn't get to initiate this. Can the seller push this back through their agent to the buyer's agent, through the buyer into the can that happen? Yes. Will that happen? I'm sure it will. You and I will be sitting here a year from now talking about the first instance of that that's become public knowledge and that we know about. But yes, is there still availability for the process to be utilized in that manner? Yes, but the gatekeeper in this scenario that we've talked about first has an obligation to ask the questions of the borrower submitting the ROV, because if they're being a little bit squishy about this, if they're really not sure, Okay. Which of the three categories does this fit into? You've got to give us a good ROV before we can put it into the pipeline as an ROV and get it considered. So you've got to meet the threshold checks on the front end to make this work. Now, the process has been there before. It's been there for a while. It can be used. Most people don't. ROVs themselves are, I don't have exact statistics for you, but ROVs themselves are a pretty low volume event. One of the additional aspects of all of this is lender requirements that they have to make their borrower aware of the fact that the ROV process exists and provide them with, I don't know if guidance is really the right word, but at least provide them with instruction, provide them with framework with, there is an ROV process if you have concerns, and here's what you must do to submit a valid ROV. There's a reason why that part was inserted into this process, further refined to make sure that the consumer is being made aware of this. Let's take this away from an ROV for a second. Now, property closes. Maybe there is a renegotiate. Maybe the seller and the buyer get back together, go, hey, we had a contract at, I don't remember the exact numbers you used, but keeping that framework in mind, we had a contract at X, appraisal came in at Y. All right, we'll negotiate somewhere between X and Y, maybe closer to Y, maybe right at Y, whatever it is. 6 months down the road, buyer moves in. Actually, they're thrilled. They got a heck of a deal. They move in. Sellers, really angry. That darn appraiser, they cost me money. Chances are, for better or for worse, their broker is probably right there with them because it cost them money too. Now they're making an issue of it and they're sending it, you know what, forget that appraiser. Send it as a complaint to the state board. Or worse yet, I'm going to file a lawsuit that appraiser undervalued the property, killed the deal we had in place, or created this gap in sales price that I've had to eat. It cost me money. One of the questions that's now available in all of this is, first of all, turning to the borrower. Well, there were concerns about the valuation. Did you go ahead and assert an ROV in all of this? One of two things is going to happen there. The borrower is going to look at this and go, heck no, I thought it was a great value. I'm thrilled. We're done here. The seller doesn't have any standing in any of this. If, on the other hand, the buyer goes through, maybe they don't meet it all the way at Y. Maybe the buyer goes through, still negotiates up from that level. Okay, they've made a decision. They're going to disagree with the appraised value, and they're still going to work their way back to some other part. And now they get in and they go, hey, wait a minute, this isn't right. And it's that gosh darn appraiser, or I couldn't get this deal done because of that gosh darn appraiser. Did you initiate an ROV? Well, no, I sure didn't. Well, then you didn't do everything you needed to do before the transaction finalized to ensure that you were getting a proper valuation outcome. If you had concerns, you had a remedy available to you, and you opted not to utilize that remedy. So why are we now here 6 months, 18 months, 3 years down the road in a litigation posture or in a license complaint posture? Because again, it's questions going to come to the appraiser. Well, did you get any communication about an ROV on this one? I sure didn't. If there's no ROV where everybody has now been made aware, particularly the consumers, legally required to be made aware of the existence of this process and how to use it, if they don't avail themselves of the opportunity to correct the problem before it's finalized, and now I'm getting into lawyer land, but before the harm attaches, you can't, baseball analogy. If you get hit by a pitch, you get first base. If the pitcher throws one a little bit outside on you and you take 2 steps forward and show your back so that you make sure you take that one square between the shoulder blades, you're maybe not getting first base. You had an opportunity there. Same thing in this context. You have an opportunity here as a consumer to get your problem addressed before it has a chance to harm you. Everything is still in process. Everything is still in flux. If you don't avail yourself of that opportunity to get it corrected when you had the chance to do so, and they had to shout from the rooftops that if you're not okay with this, if you're not comfortable, if you have questions or concerns, here's how you must raise it. If you don't do that, it chops the legs out from under the questions later in all of this. I think that's a significant detail that, again, the parts that I'm hearing are that this is going to create work. It's just going to add time. It's going to add expense. It's going to, this refinement of the ROV process, big if here, if it is utilized as intended and as drafted, and if everybody plays their role that they are supposed to play, this should actually go a long way to helping limit the liability exposure for appraisers, for AMCs, and for lenders.
Okay, limiting liability. Let's look at that for a couple of minutes. So the borrower files the ROV, the lender says, there's nothing here. And for lack of a better term, dismisses it. All right, but the borrower or the borrower's broker or the borrower's brother-in-law is still pissed off. So they say, okay, we're going to go to the state. Now, this sword hangs over the appraiser's head, pretty much whether there's an ROV or not.
Right.
Okay, that's just part of the game we play. Do you see that potential? Do you see that possibility as violating appraiser independence requirements? And then, given this sword that hangs over the appraiser, have appraisers lost or given up any of their independence? Or is it just the same old threats that there always were and it really isn't any difference?
I would tend towards the latter on that one. I don't think there's really any new liabilities or concerned. I mean, the same vehicles for liability, the same pathways exist. License complaints are going to be license complaints. Lawsuits are going to be lawsuits. Everybody's painfully aware of the federal level regulators looking at fair housing violations at this point. So that's not new. That's on everybody's radar and has been for several years now. So no, I don't see that there's any concerns there. Again, this requires the process to be utilized correctly, but no, I do not see the ROV process being a function that would impact appraiser independence concerns at all. Again, a wonderfully timely question on that one. I know this is going to sound somewhat nebulous and lofty, and I don't mean it to be, but within limitations. I was in the room in DC a month and a half ago, 2 months ago, with a lot of folks from, I mean, starting from NAR and the GSEs and ASC, but also FHFA, CFPB, FHA, all of those folks. There's a lot of folks in the room discussing a lot of these issues. Frankly, a lot of my learning and understanding about the updates to ROV were born of being in the room in that meeting while the GSEs were conversing and explaining their processes. Lyle Radke, Scott Reuter, and their combined slide deck talking about much of what, Tim, what you've put together, and you already referenced it earlier today, in sort of these are the publications that shape up the various GSE approaches to ROVs. I would say we just had a little bit of a thicker textbook on it on that day, but it was hearing from them. So a lot of my feedback on this is born of being in that meeting. I will also tell you that the folks at the various government regulatory agencies are aware of and interested in appraiser independence concerns. One of the things that was noted in all of this is, since the onset of defined AIR, appraiser independence, there really has not been any utilization of the appraiser independence regulatory structure. None of the major entities have taken enforcement actions, at least on a public level, for concerns about appraiser independence. For a variety of reasons, I think that they are very much more attuned to, aware of existing concerns about appraiser independence and the enforcement capabilities, the enforcement responsibilities for ensuring that appraisers are not being improperly, unduly pressured, influenced, and the like. The ROV process, again, is a consideration in trying to alleviate that concern. It shouldn't be the broker picking up the phone, calling the appraiser and going, come on, man, you know that you've got 3 other sales out there you can use to get this going. Or the borrower going, Miss Appraiser, I didn't even meet you at the property. I have no idea who you are. But I can't believe you wouldn't consider 3 houses down that did XYZ. ROV and shouting it from the rooftops that if you have a legitimate question, ROV is your process for getting that addressed, is probably not its primary purpose, but certainly as an intended consequence of, should actually be helpful in reducing appraiser independence violations, because the typical sources for pressuring the appraiser should all be getting notified that if you have concerns, here's how you do this, here's how you raise it. So it's not the ambushed appraiser that's saying, I can't discuss this with you. I can't answer these questions. I can't talk about my conclusions. I can't talk about my opinions. You're not my client. I'm bound by confidentiality. And for better or for worse, consumers and pushy folks have long heard that as the appraiser just not wanting to play ball and the appraiser just operating in a vacuum. I don't care how many appraisers out there have done actually a great job of explaining it. Hey, if you've got something that you think has been done wrong here, if you've got concerns, let your lender know, and then they can let me know. The consumer, who's probably already in a mind state at that point that they're frustrated, they're disgruntled, he's going, they're just giving me the brush off. They just don't want to deal with this. And I'm now, great, I'm going to talk to my lender and say, I need to get these things changed. The lender's going to come back after 3-4 days and go, oh, yeah, we looked into it and we tried to bring it up to the appraiser. They decided there wasn't any change necessary. That was just them throwing me off. I was getting a brush back and they never wanted to deal with that. For this purpose, forcing everyone into, if it's a legitimate concern, forcing everyone into the ROV process should help tamp down on any of the unintentional appraiser independence violations. The intentional ones that are going on out there, and they still are, and we know about them, and somebody needs to do something with that. The appraiser independence violations that are naturally occurring out there and with intent, they're going to get addressed in their own time, and the ROV is going to have nothing to do with that. For the unintentional but pushy folks out there that don't really understand USPAP confidentiality, they have no clue what's in Dodd-Frank, any of that sort of stuff, this ROV process should actually help alleviate some of those concerns.
Let's talk about a worst case scenario. Now, let's suppose that okay, you're the middle person for the AMC, and you send a nice letter to the appraiser and explain what's going on and give the appraiser the opportunity to respond. You're extremely professional, extremely polite, extremely empathic. And the appraiser, well, let's not say it's rude, but let's say the appraiser ghosts you and you can't get in touch with the appraiser. No emails aren't being received, phone calls aren't being returned. You send the registered letter and it comes back, addressee moved to Zimbabwe or whatever. All right. Now, so finally, there's absolutely nothing that can be done. Now it goes to the state. Now, excuse me, I shouldn't have said that. Now you get back to the lender and explain what's going on because that's your job. And the lender gets back to Fannie Mae and explains what's going on because that's their job. And Fannie Mae calls you and says, we understand that you've done this, you've done everything right, and you've been very pleasant. We've got a copy of the correspondence, blah, blah, blah. and the appraiser just won't respond. So we're going to take the appraiser off our list, and takes the appraiser off the list, which, by the way, is part of the ROV process under a very, and I must say, very limited set of circumstances, but that is a potential. Okay, so now all of a sudden the appraiser moves back from Zimbabwe and starts answering the telephone and answering emails because his or her livelihood has been taken away. What is the process, if there is such a process, of this appraiser getting his or her name back on that list?
So there is a process for all the GSEs. There is a process that if an appraiser is, we'll call it being removed from the list, but really more appropriately, it's being placed on a do not use list. There is a layer of review within the GSEs, and each of their processes varies slightly with that. But there is a process for a review or a rebuttal of that designation of do not use as well. Let's not put too much of a false sense of hope in that process. It takes a long time. It takes a lot of effort to get yourself put on that do not use list. It's equally difficult to get yourself off the do not use list. So nobody should think, even if I miss this on the first 7 opportunities, on that 8th one, I'm going to have an appeal and this will get cleaned right up. I wouldn't count on that. I wouldn't invest heavily in that fund. That said, though, if there is error, if there is mistake, if there is something substantive that needs to be considered, there is a pathway back. It's been done before, and I'll tell you, we've represented clients, we've walked them through that process, and I will tell you, we've had mixed success as well. It sort of depends on what was the reason you ended up there to begin with. Is there a legitimate, there's that L word again, is there a legitimate substantive or procedural gripe that's out there that needs to be addressed or rectified? Is there a mistake? Is there a misunderstanding? Whatever the case may be. I can tell you when it crosses over into intent land, it can be very difficult. And appraisers should probably be aware that this is not a unique function for just appraisers. It's everybody up and down the chain. It's real estate agents, it's appraisers, it's actually anybody who touches the transaction at every level. You can be a builder and you can get placed on the do not use list for the GSEs, which in essence means that if you're working on a building project and you're doing new construction and you're the builder on that project, whatever loan gets originated to satisfy the purchase of your new construction property is not eligible to be transacted to either of the GSEs. If you think that doesn't have an impact on them, I assure you it does. Suddenly, there's no lender that will take a loan on their property. It has zero to do with the risk of the borrower and everything to do with the fact that the seller is blackballed and they can't place this loan anywhere. So it's actually a much broader list than people recognize. And again, it's been up and running for a very long time. The GSEs maintain their own lists on that, though I do expect there is some note sharing that goes on. But they do maintain their own lists, so their processes are a little bit different. You do want to do everything possible, however, to avoid ever finding yourself on that list because it can be a long, bumpy road back with no real guarantee of success.
I like your comment. That's not a fund you would invest in. I like that. I think that's very clear. Well, Craig, this has run a little bit longer than these typically do. I have more questions. You have more answers, but you're going to you do a lot of speaking, a lot of traveling, and you'll be taking this roadshow, as it were, on the road to answer these questions. So let's invite appraisers to attend those roadshows to ask you these questions. If an appraiser can't attend one of those shows, how can an appraiser get in touch with you to avail themselves of your services?
Certainly. First of all, Tim, thanks very much for prompting that, but thanks for having me. It's always a pleasure to discuss these things. There will be a number of additional conversations about the ROVs going. For anybody that's unable to get to any of those occasions, or observe any of that, I can be reached. There's always my law firm website. So I'm a partner at Franklin, Greenswag, Channon, and Capilla. We are in the Chicagoland area. We're actually in the north suburbs because I bounce back and forth between Wisconsin and Illinois primarily, although we're in a handful of states, but we're in the north suburbs of Chicago. FGCClaw.com is our law firm website. You'll find all of us on there, but specifically, you'll find my bio there. Anybody looking to reach out and contact me directly, you can always call into the office, area code 847-701-2250. Good luck finding me there. As you can see, I'm working from the home office today anyway. So if your best bet is probably going to be via email, which is just my first initial and last name. So it's CCAPILLA at FGCClaw.com. If we can ever be a resource, a sounding board, an assistance in some way, even if we can't help, but if we can point you in the right direction, don't ever hesitate to reach out. We're happy to do so. We want to be a resource for that. Tim, to your other point, we are going to be taking more comments and questions on all of this on the road. My next event up, I've got a handful of state level association annual meetings / educational seminars that I'm going to be working on. I've got some stuff coming up for Illinois, for California. I think I've got something brewing in North Carolina as well. But at a national stage, the National Association of Appraisers has their appraisal summit coming up. As you and I are sitting here recording this at the very end of August, we are about spitballing here, but I think we're about 3 weeks out from the appraisal summit in Las Vegas, which just conveniently, I will actually be sitting on a panel at the appraisal summit with a USPAP instructor and review appraiser, with somebody from an AMC, with somebody from a lender, and we are going to be discussing the ROV process and what it means for all of us now. So we've got a full panel session at Appraisal Summit, hosted jointly by the National Association of Appraisers and the education sponsor for that being Appraiser eLearning. If you go to Appraisal Summit on the website, I know they're still taking registrations for that. So if anybody can make it out there, we're going to have a robust panel further developing the new ROV process, or I should say the refined ROV process, and what it means for everybody. And specifically, I'm going to be talking about appraiser-related legal concerns and all of that. So we're going to let the bank reviewer talk about that. We're going to let the lender talk about their internal processes. AMC can talk about their whole bit and how it fits them. And I'm going to be talking right to the appraiser, saying, here's your considerations. If you're on the receiving end of one of these ROVs, what does this mean for you? How should you consider it? That sort of thing. And that conversation will continue to evolve too, because again, this is still news for some folks, and it's subject to further refinement as well. So as that continues to update, heck, we might find ourselves sitting here talking about it again at some point, because it's certainly not done yet.
It's not going away. Let's see. You practice law in Illinois, Wisconsin, and Michigan. Is that correct?
So I'm licensed in Illinois, Wisconsin, as well as a number of federal districts. I actually have, believe it or not, need to get this across the finish line. I have an application in process for the state of Texas right now to get my law license there. Michigan is Michigan's on the agenda as well. I grew up in Michigan. I have long resisted getting a license in Michigan because then every family member would have a free lawyer in Michigan. So we have tried to steer clear of that. But unfortunately, I think the time has come. I no longer have the ability to avoid that. There's too much work going on over there that I'm missing out on. So I would say probably not, well, certainly not this year. 2025, however, I very well may have the license pushed through over there as well.
And then through legal cooperation with other attorneys, basically you can work in any state in the union, right?
Correct. So what will often happen is, now there's a handful of folks around the country that are absolutely fantastic, and I'm always happy to direct folks their way when that comes up. And then I may sit in the background as a sounding board, as a consultant, whether engaged or sometimes it's just, hey, every quarter we need to have about a 5-minute phone call, talk about here's what's going on. Do we need to do anything different? Do we see anything? So we'll do things that way. Or otherwise, I may get involved in a boots on the ground level by affiliating with local counsel, and again, developed some of those relationships over the years for a variety of other states as well. My dear friends in South Carolina, who have done a lot of stuff over the years now with SCPAC down there, they are aware that we are all teed up to affiliate with local counsel in South Carolina. So if anything pops up, can parachute right in there. And that's true of several other states as well.
Okay, so just because somebody lives in South Dakota does not mean they should not get in touch with you.
No, by all means, if you're not sure where to turn, if you want the input, if you want to figure out what needs to happen next, I don't care where you're located, reach out to me. We're either going to be able to handle it and get you squared away, or we're going to get you in the right hands of somebody who can. And we can figure that out, but it's more important for a positive outcome to just please reach out and let us get you the help that you need in the location that you need it.
Excellent. Craig Capilla, attorney extraordinaire. So Craig, again, thank you. And again, my best to your family. And while I will not see you in at the summit, I'll probably see you in San Antonio at the Appraisers Conference and Trade Show next in April of 2025.
Yes,
So
sir.
I'm my best, and I look forward to the next time we get to shake hands. Thank you, Craig. Appreciate it.
Thank you.
Bye-bye.